Welcome to the joint Veterans Endorsement Interviews for Judicial Candidates. We'd like to thank our sponsors today, Judge Jacob Reynolds, Department 29, and Judge Mary Perry, Department P. With us today represented are Veterans in Politics International, Nevada Veterans Association, and the Armed Forces Chamber. Again, welcome. First, I'd like to start by reviewing our format. First, the panel members will introduce themselves by stating their names and the organization they represent. Next, each candidate will introduce themselves. Please include the office you are running for and explain why you are seeking that position. We will then proceed with the interview portion. Each candidate will be given 1 minute to answer each question. You will receive an indication at the 30-second point, and then another indication at the 10-second point, and then an indication to end your comments. Panel members will not be permitted to ask follow-up questions. So I will start with round one and give you each that 30 seconds, actually, to introduce yourself, starting with you, please.
All right, thank you. My name is Pete Thunell, and I'm a Deputy District Attorney at the District Attorney's Office. I've been there for 18 years. I've got a passion for service for the community. I have a passion for safety of the community, and it's been a fantastic ride being here in Las Vegas during that time. I've really appreciated those moments of getting to work with victims, getting to work with officers, getting to work with the courts. Being in court every day has been a lot to me. And so I'm running for District Court 26, and I'm looking forward to continuing to serve this community and being a part of that. Thank you.
Good afternoon. I am Judge Jessica Goodey. I'm your judge in Las Vegas Justice Court Department 6, and I'm running for District Court Department 26. The reason I'm specifically running in this department, it is a civil department. It has been a civil department for many years, and there's a new administrative order saying it will be a civil department going forward. I was a civil litigator prior to taking the bench, and as a judge, I've had an all-civil docket. We need people with civil experience on the bench. That's who I am, and that's what I do. Thank you.
Thank you for having me. I'm Dan Hooge. I'm originally from California. I went to law school at BYU and then came down to Nevada. As my first job was in Lincoln County, rural county. I became the district attorney there shortly, a couple years after. And then in 2018, I came down here to Las Vegas and served the State Bar of Nevada as bar counsel. I am running for Department 26, and because I want to serve. I've always been in public service. I want to serve the community, and I want to do what's best for the community.
Thank you. We will begin the interview portion of our program. Jeff.
Thank you, Martin. My name is Jeffrey Lustig. I represent Veterans in Politics International. Thank you each for being here today. Clark County is a small legal community where judges routinely encounter former clients, prior colleagues, political endorsers, major donors, law enforcement officials and officers, and sometimes repeat litigants in their courtrooms. Under the Nevada Code of Judicial Conduct, recusal is required not only for actual bias, but when a judge's impartiality might be reasonably questioned. Describe a real-world scenario in which recusal would be ethically required, even though you may believe that you could be fair, and explain how you would disclose that conflict on the record without undermining public confidence in the judiciary.
I will take that question first. So I've actually had this happen several times on the bench. One of them was a former client of mine. I actually wasn't a client, but they had come in, they had been referred to me. I did a consultation for this particular person. As I'm preparing my calendar for that day, I look at it, I'm like, these facts sound reasonably familiar. So I go back and I search my files, recognize that, hey, this is a former client. I absolutely had to recuse. I couldn't do it before I wasted the party's time and had them come in. But as soon as they came in, I disclosed on the record that I needed to recuse. That's what I did. It was randomly reassigned.
Yeah, I mean, that's one of those rules that's subjective. So you have to look at it and determine what you can do and how you feel based on the situation. Obviously, close friends and family members, that's going to be a big one. I think, like the religious community that you're in, there's going to be people that are pretty close that you work with all the time. In the legal community as well, I don't think that someone who donates to your campaign, for example, would be enough, but definitely if there's a significant interest, that's when you want to do it. And the disclosure itself is what really is transparency to the public. That's what they appreciate.
You know, it's funny you should bring this question up because I ran into this just a few weeks ago, quite frankly. Come to find out, an expert in one of my cases at the district attorney's office, who's a doctor, has a different last name than, well, a last name I wasn't familiar with, and he's my wife's cousin's husband. And I saw that, we had noticed up the case, everything, and then all of a sudden, I was like, how do I know this guy? And then I realized who it was and the relationship. Now, in Cantor, we're not that close. They live kind of other side of town. We see each other kind of rarely. I just hadn't put it together. But once that came up, I spoke with the other side. They said, really, I don't think that's, I think that's going to be a problem. And so I looked at it, talked to people, and I decided, you know what, let's be upfront about this. Let's just make sure. And so I recused myself off of it and passed the case to another deputy just to be on the safe side, because I think it's important, like they were saying, it's important that we're transparent with the public, that the public feels confident in what we're doing.
Thank you very much. And I wanted to thank all three of you for coming down here and sharing this information with us. I think it's really important. In this particular position, you're going to be permitted by statute to use discretion in different cases. But what kind of safeguards would you have, or would you be relying on to make sure that you're being consistent among similarly situated individuals appearing before your court?
Yeah, I mean, obviously you always follow the law, but you're right. There are those situations where you do have discretion. And I think personally, like as bar counsel, there's a lot of politically charged cases that I have to deal with and things. And I think that one of the most important things for consistency, to make sure you're doing the right thing and make it as objective as possible, is to kind of roundtable with other judges, roundtable with your staff, and say, hey, this case has some nuances to it, and we need to discuss this. Help me to be as objective as possible, make sure I'm not being overly subjective and biased one way or the other.
Great question. Really, at the end of the day, I think what's going to come into a lot of decision-making, things like that, is also what chance you've had to encounter these things, what chance you've had to work within these kinds of things, especially when we're talking about, for instance, with crimes that have been committed, people who've come in when you're looking at a sentencing, for instance. You want to make sure, as you said, you want to make sure that you're consistent. You want to make sure that you're treating everybody fairly. And so I think with my experience with tens of thousands of cases, with so many instances of chances to kind of look into these things and also to kind of come to those decisions, I think that that's going to be important to make sure that everybody gets that same fair shake. And I think you have to, like you said, you have to always stay cognitive of it. You have to be really thinking about it, and you have to make sure that that's up at the forefront of your mind in all of these things.
Yeah, I mean, basically ditto to what they said. Every case is treated the same. It doesn't matter who you are, what the case is about, where you're from, who you might know, how much money you have, what you're wearing, what your political affiliations mean, what they may be. It doesn't matter for me. I'm looking at the law and I'm looking at the facts. And so when my discretion applies, it's applying the law and the facts, but it has nothing to do with who the person is in front of me. It's what the law and the facts are of this particular case. And then making sure everybody is treated fairly with kindness, dignity, and respect. That happens from the moment you walk into my courtroom until the moment you leave.
Thank you.
Thank you. Thank you all for being here. Well, I'm going to start with you, Judge, and I'm going to ask you a hypothetical question.
That can get me in trouble.
Do your best. A celebrity defendant seeks to delay trial repeatedly, citing schedule conflicts and media prejudice. How would you assess whether continuation as warranted?
So again, without being able to make any comments about how I might rule on an issue that could come in front of me, and those issues do come in front of me all of the time. Generally, when I'm looking at trial continuances, my general rule has been both sides can continue trial one time with pretty little consequences, because things do come up. If there's a second, a third, a fourth, a fifth request without the other party agreeing to it, I am taking a very close look at it. If they're saying something has come up, they need to establish with facts and evidence that something has actually come up. They can't just say, oh, we're not ready, or, oh, I've got this doctor's appointment, without actually showing me. You need to prove that you can't go to trial and receive a fair trial if it doesn't go forward as scheduled. My job as a judge is to move cases forward and get things heard.
Thank you.
Yeah, thank you. I had a recent experience where there was a case that came before me that was very politically charged. and there was a parallel criminal case as well, and the respondent in that case, the attorney that I was prosecuting, was asking if we could put it off, and there's a lot of requests for continuances, and very similar to Jessica, I'm usually pretty amenable to that for the first time, but after that, I think efficiency is so important. We have to move things along, unless there's a really good reason, obviously death or something tragic. We need to move those cases along. We got to keep that caseload going and the efficiency moving.
Thank you. Dave, great question, because I at the district attorney's office run into this all the time, especially, there's just certain cases where somebody's just dragging their feet, and you know that they're dragging their feet. They don't want to go to trial. They're out. They don't want this to go forward. They know what the evidence is. And so it's incumbent on the judges, and there's certain judges who do a really good job of it, I think. And what they do is, as people come in saying, hey, can we push this off again and again, they start to really kind of lock it in. They're like, okay, we're going to do a status check in a week. You're going to tell me, you said you need this new discovery. What are you going to do to get it? What is that new discovery? So you've got to become a lot more detail oriented. You got to kind of hold feet to the fire. And I've seen it work. And when the judge does that, cases start to move. And just like Dan and Jessica said, these cases got to move. There's a lot of cases in Clark County, and it's got to be done. Thank you all.
Joanna Farrakhan with the Armed Forces Chamber, and we'll start with Pete. My question is, describe a time when you had to make a legally correct decision that was unpopular with your clients, colleagues, or the public, or all. How did you handle it?
Those are tough times, right, Joanna? It's tough because when you have people who you work with and they don't like your decision, it's tough. But one of the big things that I do in my job is I'm a team chief, and I've been a team chief of multiple different teams over the last few years. And part of that means that I have to evaluate cases, and I have to put a very clear-eyed, very distinct look on these cases, and we have to decide, can we prove this case beyond reasonable doubt? I have an ethical duty to that. And so because of that, I'm talking with cops literally every day. Every day we're talking about cases, we're talking about it. And there's sometimes where I say, listen, I know you're telling me this guy's a problem and everything, but it's not there. We cannot charge this because we're missing X, Y, Z. And we'll go back and forth and everything. And sometimes they're not happy about it. But at the same time, I also talk about it. We discuss it so that they can get to a point where they understand. I'm not just kind of throwing things out or anything, so they can understand where I'm coming from on that. And I think on the bench, that's exactly what I want to do, is obviously going to have to make the tough decisions. And I'm not afraid of making the tough decisions, but at the same time, you let people know why, so people understand where you're coming from.
Thank you. This has obviously happened several times for me. The one instance that comes to mind, one of the cases or the types of cases I see quite often are credit card collection cases. It's all under NRS 97A. And there are very specific statutory requirements for the credit card company to establish both the liability and the amount of damages. There was a portion of that statute that was not being followed by my predecessors or colleagues until I came on the bench. I looked at the statute with fresh eyes, and I started enforcing it as it's written, requiring the technical requirements. That slowed down a lot of these credit card cases because they're in such high numbers. They had to go back to these big credit card companies and get custodian of record affidavits, which hadn't been required before. There were a lot of problems with that across the bench, but that's my job. It's to enforce the law as it's written and to apply the law as it's written, not as what we might want it to be or what makes it easier to apply.
Yeah, this reminds me of a case I had in Lincoln County when I was district attorney. We had a high school principal there that was also the football coach. They hadn't lost a game in like 10 years. Really, really popular with the community. Everyone loved him. But it turned out that he was embezzling money from the school district. And pretty much everyone told me, do not prosecute him. Turn it over to the AG's office. And there were some other reasons why I couldn't do that. I had to stick to my guns. And even though I had been elected twice, they ended up running me out of the county because I even talked to one woman and I said, well, we have very strong evidence. There's financial records and it's all very clear. And she said, I don't care. We love him. Don't prosecute him, And so if anyone knows me, I'm going to do what's right, regardless of the consequences.
Good afternoon again. Martin Walker, Nevada Veterans Association. A significant portion of the public is concerned that lenient sentencing erodes public safety and minimizes the suffering of victims. Conversely, many advocates argue that incarceration without addressing underlying circumstances, underlying service-connected trauma, such as PTSD or TBI, doesn't mitigate recidivism and doesn't adequately improve public safety. So my question is for all of you, what specific criteria do you consider to be valid service-connected circumstances and would make a person a good candidate for some type of diversionary or alternative sentencing versus maybe throwing the book at them with some punitive action? And I'll start with you, please.
Yeah, I think this goes back to mental state. You know, as a bar counsel, when I prosecute attorneys, we always look at mental state. And if they're doing something intentionally for personal gain, that's a lot more serious. That's where we seek disbarment or we seek to suspend that attorney. Whereas if they were negligent or they were doing it for maybe not the right reasons, but for some mitigating reasons. There's some reason why they had to do it, you know, stealing bread for family because you're hungry or whatever. And there is a fine line there, but you have to distinguish those that are, you know, just bad for the sake of improving their own lives, and then those that have some good excuses and mitigating circumstances that you can say, hey, with some treatment, they can really turn their life around.
I'm asking for veteran service connected, not in general.
Okay.
10 seconds.
Okay. Yeah. I think, like, you take, for example, PTSD. You know, that's something where you can look at it and say, all right, was it violent? Did they do something intentionally to harm someone? Or was it something that because of their stress and the trauma that they go through, that they just made a mistake or that they were forced into a circumstance?
So if they are identified as a veteran, or we can identify them as a veteran, in Las Vegas Justice Court, we can send them to our Veterans Treatment Court and to see if their case or they personally qualify for the diversionary program. If they don't qualify for Veterans Treatment Court, we could potentially get them into mental health court. We have drug court. We have a lot of diversionary programs. So I can't say a specific thing that I'm looking for, but for veteran services, as soon as they're identified as a veteran, we start looking to see if we can put them in Veterans Treatment Court if their case qualifies for whatever the crime that they're alleged to have committed. You know, if it's a violent crime, a lot of times that's not going to qualify for the program because of grants and other funding issues we have. But if it's a lot of times we have a quality of life charges, homelessness, trespass, those types of things, drug offenses, those are really strong diversionary type cases that we've seen a lot of success with.
Yeah, over the last 18 years through my career, it's been fun to watch all these new programs come in. I say new, they've actually been around for a little while, but it's been wonderful to see the veterans programs in the courts, the drug programs, co-occurring court, mental health court. So all these different things have been put together to help those who need, as we talk about, the people who need that help. When we're talking about veterans programs, I know, and I'm sure Jessica does the same thing, in Justice Court, they often say, hey, are you a veteran? That's a normal question you hear almost every day on almost every case. They want to know. And we all do. The prosecutor, the defense, we all want to know if they're a veteran, if they're going through anything like that, because we want to get them that kind of help. It's an important part of it. Now, are there instances where also sometimes, as you said, there has to be a punitive part? Yeah. I mean, sentencing's hard. Sentencing's really difficult. You got a pre-sentence investigation. It's a lot of pages. I've done thousands of them, quite frankly, and you don't want to just treat it all like it's the same thing, but you want to make sure you're helping that individual to help the community as well.
And just in case you're wondering, my name still is Jeff Lustig with Veterans in Politics International. I've been saying it all day. I had understood that Department 26 was all civil. Is that right? Okay, so I've kind of retooled my questions away.
I wasn't aware either.
So that, and I understand that. But I do have a question that is related to some of the topics of the day that have been in the news. One of those is recent news reports have highlighted the persistent delays and growing backlogs in Clark County's civil courts, raising concerns about prolonged case timelines and their impacts on everyday litigants and local businesses, landlords, individual parties seeking justice in their civil cases. In that context, Is the current system of mandatory non-binding arbitration dispute resolution in Clark County working as intended, or are there types of civil cases where requiring ADR just adds time and costs without meaningfully advancing the resolution? And should these cases instead go directly to the judge and be fast-tracked for trials on the merits?
I will be happy to take that one. So I do think it is working. It has not resolved all of the backlog. It is a huge issue. So in my department, I have 8,500 cases, civil cases assigned to me, and each of my other two civil colleagues have that much. We are the busiest court in the nation, the Las Vegas Justice Court.
How many JPs have that?
3. 3 JPs handle, I think, like 60% of the entire Las Vegas Justice Court caseload. So, because that's the civil portion of it. So, in the district court level, if we were to remove the arbitration program, which was just recently expanded to take some additional work off, all of those would go straight to the judge, and that would add so much more to the backlog and making it so much more difficult to get a trial date. Part of the issue is we have certain cases that require firm settings and get priority. Medical malpractice, elder abuse, things like that. They get priority. So some of these other business cases may not get a firm trial setting, and that's what extends it out. But I do think the arbitration program is working.
Yeah, I have to agree with Jessica here. I think the arbitration program, the short trial program, those types of like early intervention programs are really successful. We probably can add some support to it. We can expand that, obviously. But anytime you can get two parties together and you get someone who's trained and experienced at mediating that, I think you can have some really positive outcomes. And if you can get them screened so they're out and they never make it to court, that's best for everyone.
Going along with what they said, there's a lot of benefit, obviously, in having the parties being kind of pushing the parties towards trying to come to a resolution. I've sat through many settlement conferences where we sit down, there's a judge there, and we try and see if we can't kind of get to a resolution so that we can move things along more quickly. And that's something that's been just new over the last few years. That didn't exist for a lot of time before. Now, I've also know that sometimes these kind of settlement things will be used by people as a ploy to kind of, push it along, drag it on. And I agree. Once again, we have to keep things pushing along. And so I think it's important to have the judges who are ready with that litigation background, with trial background, so that they know if they're going to go through the ADR program. If it doesn't work, we're going to trial. We're ready for it. So I think that's important.
Can you clarify for me, are you working in the civil division or the criminal?
I'm in the criminal division, so I'm just talking about within the criminal. I will say, and it is a civil division right now. As we all know, with the district courts, what happens is it changes a lot of times as to basically the chief justice as they come in with the dockets. They'll look at where have you come from, and they'll change the dockets off. And so a lot of times, most of the courts right now are split. They'll do civil and criminal. And that's pretty common what happens on it.
And again, I'm adjusting to understand and trying to give you more civilly minded stuff as opposed to criminal. What would you define, and we'll start with you gentlemen, what would you define as the appropriate boundary between interpreting statuses as written and effectively expanding those statuses through judicial interpretation, especially when it involves whether it's contracts or large companies versus people who aren't as liquid financially and stuff like that?
You say status, you mean statutes?
Yeah, statute.
Okay,
gotcha. Interpreting the statutes as written and using your judicial interpretation, and then also how that might align with talking to two different parties that have quite diverse economic situations and representation.
Right. I'm a very strict constructionist. I mean, the law is usually black and white. Usually, we only need to interpret it when there's an ambiguity. And so I think that's one of my major focal points is when someone says, I just look at the case law. Well, first you got to look at the statute and determine if there's any ambiguity. If there's no ambiguity in the statute, then you follow the statute. You don't need to look at case law. And so it's so important that we as judges don't try to impose our own interpretations into things that don't need an interpretation. We can't be activists. We can't push our agenda. We need to follow whatever the statute says.
I'm going to go right along with that. I mean, I think it's really important, obviously, that you're going to come in. I mean, everybody has opinions, right? And everybody has feelings, but you have to really kind of strictly kind of construe what you're going to be doing with the statutes, with the case law. It sounded like part of your question also was when there's kind of a disparity, be it in power or money or whatever else. And I think that obviously that's really important too, because sometimes somebody coming in, especially on the civil side, without the high-priced lawyers, without that kind of thing, everybody needs to feel that they're getting the fair shake at the end of the day. And I think that's what's important is throughout my career, obviously trying to make sure everybody gets that exact same fair shake, no matter where they're coming at it from.
And I will just go along right with them. I do not believe it's my job to legislate from the bench. I think your question was, how do I look to expand the effect of a statute? I don't. That I am not here to expand the effect of the statute. If it needs to be expanded, there are people that are elected to do that every other year in Carson City, and there's not enough money in the world to have me do that. So that is not my job. It is not what I want to do. And that answer doesn't change whether it's to super wealthy companies or whether it's to self-represented litigants, or if there's a huge disparity. It's the same no matter what.
Thank you very much.
Thank you. David Farrakhan with the Armed Forces Chamber. Judge, I'm going to start with you with my question. Tell us about a legal position you once strongly held that changed after further study or experience, and what caused the shift.
It's not necessarily a position that I strongly held, but there's a recent case that I had in front of me that I applied a statute the way that, based off of the arguments that had been made and the evidence that was in front of me, the person who lost the case brought back they got an attorney, made different arguments, filed a motion to reconsider. Based upon those arguments, I looked at it, which actually then led me to go into the legislative history of the statute. And so I thought the statute meant this, that they established to me, and they brought something up, led me to look way farther deeper into it. And it was an unlawful towing statute. It's kind of a weird set of circumstances. But I have no problem admitting when I'm wrong. So I reversed my decision and I said, okay, I was wrong. I did not see the statute the way that it was intended to be written.
Judge, thank you.
Okay, thank you. And so, David, kind of going along with the same thing, on many instances, I should say many instances, sometimes you do have that position. You know, you've been working in this area of law for such a long time, you just kind of have a knee-jerk reaction like, well, of course, it's going to be that. And so I'm having a hard time thinking of an exact one, but I know on multiple occasions I've come back and I've reread a case on it, or I've reread the statute, and I've thought, you know what, I think there's something else there. And I think that's important. I think what Jessica just said is important. You can't just kind of come in, have this idea of, this is how it is, I'm not going to rethink it. You have to be open to rethink. You have to be open to reading it again, reading it a third time, even a case you've read 10 times before, because sometimes that 11th time really does make the difference. And so I think that's what's important, is you have to be open to understanding more, be humble enough to say, I know a lot, but I can know more, and I've got to keep kind of diving into it.
Thank you, David. Yeah, I think there's always an opportunity to gain wisdom from experience, and there's a lot of areas where I could say, yeah, I've changed. I think one good example is just coming in fresh as a brand new attorney. In 2007, I remember I was very strict when it came to like drug crimes and things. I thought, these drug courts are just a waste of time and they're not very successful. And I hated when defendants that I was prosecuting would request that under Chapter 453. And then over time, I realized how successful they can be. In Lincoln County, we had like a 70% success rate, and they're so beneficial to the community. And so that's just one example, but there's many others, obviously.
Thank you.
Joanna Farrakhan, Armed Forces Chamber, and I'll start with Daniel. If you discover post-election that a campaign volunteer made a statement inconsistent with judicial ethics, what steps would you take?
Well, first of all, I think you gotta handle it. You gotta address it, and you've got to. Depending on the circumstances, you should report that. And obviously, you got to look at that statement and say, I don't agree with that. Make sure that you had the appropriate training in place for your staff, and hopefully you did, and then it was more of a rogue statement. But yeah, I think you got to get out in front of it and take whatever the consequences are, and accept that, but then make sure that the public knows, hey, that's not how I do it, and I train my staff.
So I think the answer, like most things in the law, is it depends. If it was made by somebody who was not the successful candidate, then maybe I have a conversation with that person. Maybe they know about the fact that the statement was made, or maybe they don't. That way, if they do decide to run for election in the future, that they can address it and ensure it doesn't happen. But if they weren't successful, reporting them to judicial discipline isn't really going to help anybody. It's not going to affect the outcome of the election. If it was for the winning candidate, again, it probably depends upon the severity. And I probably start with having a conversation with the candidate to see if they knew about it, whether there was an authorized statement, and how significant it was, and whether it potentially impacted the outcome of the election. If it did, if it is a significant enough violation, then it needs to be reported to the Judicial Discipline Commission, because that is who oversees us even as judicial candidates.
And just going along with that, I agree with exactly what Dan and Jessica said. You have to get out in front of it. I think you also have to use your wisdom and look at it, find out exactly what it is, and make that determination. But I know all three of us are all parents, and so it's something that you teach your kids, right? You're like, listen, sometimes you got to take your lumps. If something bad has happened, you can't go and try and hide from it. If it's something that needs to be addressed, you got to address it, and it's important. I mean, as a judge, I mean, what else can you do? I mean, you have to be ahead of it. And even when it's hard, even if it's embarrassing, you have to address it. You have to address it with the person. If it needs to go beyond that, then it's got to go beyond that.
Thank you. All right, so one of you mentioned in the last questions about training for the staff. So I want to ask a question along the lines of training and preparedness for the different litigants you might see in before you, regardless of whether it's civil or otherwise. So Nevada authorizes cultural competency training for judges, for judicial officers, which includes understanding the unique needs for veterans, such as military culture, trauma, and behavioral health, to ensure fair, informed courtroom proceedings. So starting from right to my left here, I guess, have you completed veteran cultural competency training or any of the cultural competency training? But because this is a veterans forum, I'm asking specifically about veterans. And if not, would you be willing to do so? And would you be willing to strongly motivate your staff, since you can apparently have that capability to also take some cultural competency training for veterans?
I mean, it'd be weird if I was like, no, I'm not going to do that. I'm just kidding. I'm just teasing. No, actually, no. Yeah. Over there, Dan and Jessica are like, Pete doesn't want to. No, listen, I love it. I mean, as part of an ongoing, we have an ongoing obligation to learn more. I mean, and so you have the CLEs. And so that's something we're doing constantly. I know at the DA's office, and I know with these guys as well, we're constantly doing classes, and we're learning about all sorts of things. I got to be honest, this is the first time I'm ever hearing of this. I didn't even know. And I know my office, I know the judges. I'd be shocked to find anybody who wouldn't be interested in this, because it's such an important part of it. And because veterans really do have a certain kind of set of problems sometimes that really need to be addressed. And I think that sounds like something that'd be wonderful for staff and for everybody to do. I'll let the other ones, I will be surprised if they say yes as well. But basically sign me up. I think it's great. I think it's a wonderful thing. And I think it's something everybody should. I think it should be part of our CLEs, definitely.
So I haven't done anything specifically through the state of Nevada other than through, I believe there was a class on it at the National Judicial College. I can't remember. However, I'm part of a nationwide organization of judges, the American Judges Association. I'm actually on their board. And through that organization, we have done cultural competency specifically related to veterans. Similarly with the statewide organization of limited jurisdiction judges, I'm on the board, and I'm helping schedule our educational sessions and continuing judicial education. We do trauma-informed CJEs, or continuing education classes, almost every conference that we do, and we do those twice a year. Same with the American Judges Association. So there hasn't been anything specific through the Clark County, but through other organizations that I'm a part of, I have had some of it. And of course, I'm willing to always take more.
Yeah, I feel like that episode on The Office where they're all like, I'll take the chicken piccata. Because, yeah, same answer, ditto to what they said. It's just so important to train staff and to understand, because everyone's got a different perspective, and realizing that perspective is so important. I've got a brother that served in the Army, and he has some PTSD issues, and I'm currently helping him pro bono with a civil case related to his PTSD, and it's amazing to me how insensitive the other side can be to those PTSD issues. So.
Are you still done?
Yes, but I'm making sure we have time because these answers have been kind of short, so we do have some time for some bonus round questions. So
this might be the first time lawyers didn't talk too long.
I know, right? Where do you get my bill? Yes, I still remain Jeff Lustig. I still am with Veterans International, at least for the next half an hour. In Clark County, our judges carry some of the heaviest and most emotionally taxing dockets in Nevada. In recent years, we have seen judicial officers experience personal crises, including needing to go to mental health treatment, needing to go to alcohol treatment. Sometimes it includes divorces, maybe even getting arrested for DUI, that sort of thing. And we've even had a judicial officer who has committed suicide while in office on the bench. And when this happens, it always leads to questions about managing personal stress and burnout, and also accountability issues. And I'm just wondering if you can outline for us what the limits are. What will you do if elected to maintain work-life balance? And where do you see the appropriate level of accountability when you serve as judge in this community? Can you comment on that? I don't know who's up. Who's up next?
Yeah, I think work-life balance is so important. You've got to get involved in other things. Religion's a big one for me. Family's a big one for me. I've got 6 children, and I coach a lot of soccer and basketball and things. You've got to be able to get out in the 3 days a week. In the morning, I play basketball with guys in the community, and you've got to be able to do those things to where you can kind of get away from the stress a little bit. And anytime, if I feel like I'm not all there, I can't do it, I'll take action, obviously. Fortunately, that's never happened, knock on wood. But I think you have to be focused, and you got to be able to do the job. And you're right, this is a high stress job. And if you can't handle it, you need to take action, and you need to be able to recognize that. And so I'm very sensitive to that. Listen, I'm humble. If someone tells me, hey, Dan, you need to take a break, I'll do it.
Oh, no, he pointed at me. Sorry.
Laura's been lost to that.
Please.
Okay. I wasn't like trying to elbow you out there. Listen, Jessica. No, great question. So right now I'm the team chief of the Special Victims Unit at the Clark County District Attorney's Office. And so sometimes it's not just the weight of the amount of cases, because we are probably one of the most busy district attorney's offices in the nation, quite frankly, if you look at the caseload of myself and the people on my team, but it's the weight of what it is as well. And I know we all carry the weight of what we work on, because these are weighty matters. Even one case that we're working on, there's a lot that depends on it. So you're right. It's finding that time. It's I got a wife, I've got 4 kids and everything. It's finding that way to kind of connect with them, but it's also finding a way to get your mind in that place where you're not kind of spinning out. Because you mentioned some different people. I know these people a lot of times, and I've seen it, and it breaks my heart because they're friends, and it's hard. And so it's taking care of myself, but it's also taking care of others. I mean, the people, defense attorneys, other DAs, judges, whoever it is, it's as a community making sure that we're taking care of each other on that level, I think is important. And so taking care of myself is part of that.
Right, I'm going to speak quickly because there's a lot to unpack there. So on a personal level, I do, as they both said, finding outlets. I do yoga. I'm running. I running the half marathon. If anybody wants to join me tomorrow, come run down the strip. From a colleague perspective, I do think that we owe an obligation to our colleagues. When we see something, we need to say something. And I think it starts with a conversation with that person. If you're not close enough with that person, find their friend on the bench and say, hey, what's going on? Is everything okay? Do you need help? offer to help, handle some of their stress. If there continues to be a problem, it probably needs to be reported to the chief judge. And then it's kind of up to the chief judge to do some investigation of that, and then report it to the disciplinary commission and take further action if necessary. But again, through my additional organizations, my judicial organizations, mental health is a requirement in every single conference. There is at least an hour of mental health education on every single conference that I attend, and I attend for a year.
Thank you very much. I'm John Brookhagen. I don't know if I ever said it. Veterans in Politics International. And this is going to be the last question, and I'm going to require each of you to answer it differently. When I was younger and growing up, even when I became more politically aware, it was always very clear that the executive branch, the legislative branch, was very partisan, and it was very understood that the judicial branch was supposed to be nonpartisan. And as we've devolved, for lack of a better word, over the past decade or so, it's starting to feel like you have partisan judges that are kind of judging according to their particular beliefs or the city or the constituents that voted for them. And of course, I've observed that you guys seem very constitutional or by the books, and you're not going to go too far off the branch. But I want to know what your opinion is of the public's opinion of judges, and how, I'm sure I'm not the only one that feels like judiciaries and judges are becoming part of the political machine, and you got to wonder which president appointed a particular federal judge or what county a particular judge is from to know what the chances are or what kind of laws they're going to enforce. Of course, you guys seem to be very by the book, but what do you think about the reputation that the judiciary has kind of devolved into over the past 10 years?
Well, it's tough because all three of us, not just, as judges or our current jobs, you want people to respect what you do. And you want people to feel like, hey, when they find out what you do, they're like, that's, I don't want to say noble, but that's something, that's a great thing. That's something that serves us in our society. And that's what I strived for. It is hard. It's hard when you see people kind of look at the judiciary and say, oh, well, it's just, it's this. So they're just going to, they're this, so they're going to rule that way. And so I think it kind of goes back to kind of the grassroots of what we're talking about. Everybody who's up there with a robe on, who's making those decisions, you've got to prove it every day. You got to prove it every day. It's the same way as at the district attorney's office. I got to prove every day that my job isn't just to throw everybody in jail. My job is to make sure the right thing happens. If that's dismiss a case, negotiate a case, whatever it is, the right thing. And so as a judge, every case, you've got to be laser focused on making sure the right thing happens, no matter what. And that's how you chip away at that idea. I know it's hard. It's hard when the masses are saying something, but at the same time, that's the way you can do it, is by showing it through your example.
And I'd like to know how you personally feel about, your profession being called into question. I'll give you 5 more seconds.
Okay, I'll take 5 seconds. It's sad. It really, breaks my heart, because you want people to, we should have the most noble of the professions. This should be the one thing that everybody can say, hey, we're going to get that fair shake. And so it's sad. I wish it wasn't that way.
Thank you.
Yeah, unfortunately, the public opinion of the judiciary is at its lowest point ever in history. And that is a problem both just on how we are able to do our jobs, but it's also become a judicial safety issue. People feel much more able to make threats against us. I've had death threats made against me just for doing my job, and that's not okay. So the public opinion of the judiciary, some of it is well-earned, some of it it's not. How we combat against that is by continuing to do our job fairly, efficiently, and without any bias. It's pure and simple. We are constrained on our ability to speak publicly about decisions we're making and why we might have reached them. But it's my hope that if I continue to do my job and help my colleagues do their job fairly and efficiently and without prejudice, the public opinion will improve.
Thank you. And Daniel?
Yeah, echoing those sentiments from Pete and Jessica, I think the opinion of the judiciary is definitely in a downward trend, and that's concerning. That's concerning to me. I think as bar counsel, when I prosecute an attorney, one of the things that we look at is the harm to the profession. And that's a big factor. So, if you're harming the profession, then that could affect your license. And it's the same thing with the judiciary. We have to look at it and say, what can we do to be more transparent? What can we do to help the public understand? And one of the most important things, too, is to stick to the letter of the law. Don't try to go outside of that. Don't try to interpret things. If it's black and white, stick to the black and white. We don't need to look for gray and everything. And do the best that we can to reach out to the public. I think that's important for me. That's important should be important to all judges to reach out to the public and especially in your cases and your opinions, why you did the things that you did.
I just want to thank you all once again for coming down.
That concludes that portion of our presentation. We'd like to give you all 1 minute for a closing remark, starting with you, please.
All right. First of all, thank you so much for having us here today. This has been wonderful. It's been exciting to answer these questions. This is my first time running for anything. And so this has been really interesting. It's been a fantastic kind of chance to go out there and kind of get myself out into the community and to really see a lot of people out there and see how much they care about the judiciary, how much they care about what's going on in the courts. It's something I've cared about for obviously 18 years as public servant in the district attorney's office, working these cases, tens of thousands of cases, if not more. And I'd like to think that I bring that experience into becoming being the judge there. It's something that I look forward to doing. I look forward to following the law. I look forward to diving in, working extremely hard, but also to lifting up the people. Hopefully that they can also feel strongly about the judiciary, that they can feel that this is a noble thing. And so that's what I look to do. Thank you.
Well, again, I will ditto the thanks for being here, and thank you for giving me the time of day and giving me a microphone in my hand. That's always a little bit dangerous. So again, I'm running because this was not on my bingo card, candidly. I am running because Judge Sturman retired. This has been a long-time civil case, and we are losing our civil judges. And we need to replace them with people who have that experience so they can come in on day one and handle those multi-million-dollar cases, those business disputes, the smaller disputes, the foreclosures, the evictions. That's who I am. That's what I've done for the last 15, 17 years. I can't remember at this point. But that's what I'm doing. This is coming at a little bit of a personal sacrifice to me, but it's what our community needs, and that's what I'm dedicated to doing. If you want to know more about me, find me on my website, Jessica Goodey for Judge. Come hang out at my campaign kickoff next week, and if you want the courts to get better, get Goodey.
That's pretty catchy.
He loves it when I say that.
Come on, Jessica. My name doesn't rhyme with it.
Yeah, again, thank you for having us. It was a little bit intimidating at first to have you all there, and you've been great and easygoing, and I appreciate you. I'd just like to say, we've got 3 really great candidates. I know Jessica from serving with her when she was on the Board of Governors. I don't know Pete, but we run in a lot of the same circles, and he's got a pretty impressive resume. Too bad the legislature can't just pass that bill where they enlarge the court a little bit. I think we'd be 3 great judges. I think what sets me apart, looking at it, I'm a business major. I had several businesses that I ran through my younger years. I'm very efficient. When I came to the state bar, we had a huge backlog, 800 cases, and I put the machinery in place to make sure that we were very efficient. We ran things through. We're now one of the quickest in the nation as far as prosecuting attorneys and getting those cases resolved. And I want to do the same thing on the bench. So thank you.
Right. Well, thank you all again for coming, and thank you for your time.
Thank you very much.